Well, appearances.
May it please my lordship, I am Okuosa Chukwudozie. I announce my humble appearance for the claimant, my lord.
Any other appearance?
With preference respect to this honorable court, CG Ike Okafor. CG initials, my lord. Ike Okafor is a compound name for the defendant. We sincerely apologize for the defendant.
The judgment ought to have been delivered yesterday, but in view of the public holiday, that's why it has to come up today. So I'll go ahead and deliver the judgment.
Very well, my lord, as the court pleases.
Yes. It is the claimant's case that he is a citizen of Lebanon, but an employee of the defendant, and that by virtue of the employment contract, is entitled to $5,000 monthly salary and $1,500 as cost of living payable from January 2020. It is his averment that he was accused of being in breach of his employment by being a separate business other than the one he was engaged for, and which allegation he denied, that he has been helping a friend with a business which is not competitive with that of the defendant, for which he was put on verbal suspension without pay for 1 month, and claimant was asked to hand over all his office materials. He continued that he was summoned to the head office of the company in Beirut and Lebanon, where he denied the allegation. He caused a letter to be written to the defendant after he was not reinstated after his trip to Lebanon, to which the defendant responded by giving him a query. He responded to the query through his email. He averred further that the defendant mistreated him and is deliberately refusing to pay his entitlements, that unless the court intervenes, the defendant will continue to withhold same. It is against this backdrop that claimant filed a general complaint against the defendant, wherein he claims as follows. A declaration that the claimant is entitled to pay the total sum of $30,000 by the defendant at the rate of $1,500 per month from January 2020 till August 2021, which represent cost of living after completion of 6 months from joining date, as contained in paragraph 2 of the entitlement clause, which the defendant held in arrears from January 2020 to the day this matter was filed. B, a declaration that the claimant is entitled to be paid his salary for the month of August in the sum of $5,000, having been unduly placed on leave without pay by the defendant. C, a declaration that the claimant's employment offer letter dated 11 June 2019 is still valid and subsisting, same having not been validly terminated by the defendant. D, an order of this honorable court directing the defendant to pay claimant the total sum of $30,000 by the defendant at the rate of $1,500 per month from January 2020 till August 2021, which represent cost of completion of 6 months from joining date, as contained in paragraph 2 of the entitlement clause, which the defendant held in arrears from January 2020 to date. E, an order of this honorable court directing the defendant to pay the claimant the sum of $5,000 for August 2021, which represent basic monthly salary, as contained in paragraph 2, entitlements of the claimant's employment offer letter dated 11 June 2019, having been unduly placed on leave without pay by the defendant. F, an order of this honorable court directing the defendant to pay the claimant the sum of $1,500 per month from September 2021 till the day judgment is delivered, which represent cost of living after completion of 6 months from joining date, as contained in paragraph 2, entitlements of the claimant's employment offer letter dated 11 June 2019. G, an order of this honorable court directing the defendant to pay the claimant the sum of $5,000 per month from September 2021 to the day the judgment is delivered, which represent basic monthly salary as contained in paragraph 2, entitlement to the claimant employment offer letter dated 11 June 2019. H, an order of this Honorable Court directing the defendant to pay the claimant the sum of 10 million naira as general damages, and I, 2 million naira for the cost of this action. The defendant in response stated that claimant's employment is directly bound by the employment contract, and which contract entitles him to the sum of $1,500 as cost of living from January 2020, but which sum was not paid to claimant because he breached his obligation under the contract. The employment of the defendant registered a private business name called G-Tech Engineering in total contravention of his terms of employment, and which business is competitive with that of the defendant. It is part of its averment that claimant also engaged his co-workers in the running of his private business during the official working hours. It also alleged that claimant at some point posted pictures of the defendant's LPG tanks on an online site with the intention to sell without the consent of the defendant. It stated further that in June 2021, claimant was caught via a CCTV footage stealing tools and equipment from the defendant's store, which resulted in the setting of the panel to look into the matter, and the claimant gave an unconvincing defense during the inquiry into the matter. It also denied that it has the head office in Beirut, Lebanon, and neither was it privy to the claimant being summoned to Beirut to defend any allegation. It is part of its averment that it received a letter written on behalf of the claimant, and in response to which claimant was issued a second query to which he responded. It is the position of the defendant that it is not willfully refusing to pay claimant any entitlement, as the claimant can only talk of an entitlement when he has returned the items stolen by him. It equally averred that all the allegations leveled against claimant are true, and in respect of which a criminal action has been instituted against claimant via direct criminal complaint. By way of a counterclaim, it is the defendant counterclaimant's assertion that claimant posted pictures of its LPG tanks on an online market store called GG with the intention to sell thereby provisionally passing off. It equally contended that claimant was caught on the security footage on the 16th of June 2021 after the block snuck into the storage unit of the defendant to steal some tools and equipment of the defendant counterclaimant. The defendant counterclaimant counterclaims against the claimant defendant to the counterclaim as follows. A declaration that by virtue of the employment offer letter dated 11th day of June 2019, the claimant is an employee of the defendant. B, a declaration that the claimant's act of posting the defendant's LPG tanks on an online market store called GG by the claimant with an intention to sell without the consent and or authorization of the defendant violates the defendant's commercial rights and privileges and is as a result in tortious breach of passing off. C, a declaration that the claimant's act of registering and establishing a business entity known as G-Tech Engineering while under the active employment of the defendant is in total violation of the obligations owed to the defendant. D, a declaratory order mandating the claimant to pull pictures of the defendant's LPG tanks from the GG online market store and seize and desist from passing off same on GG or any other online or physical market whatsoever. E, an order of this Honorable Court directing the claimant to pay the defendant the sum of 15 million naira as general damages for passing off the defendant's LPG tanks without requisite consent and authorization of the defendant. F, an order of this Honorable Court directing the claimant to pay the defendant the sum of 106,365 naira, being the total cost of items stolen and or removed from the defendant's company by the claimant. G, the cost of 5 million naira as litigation cost of defending the action against the claimant and prosecuting this counterclaim. And H, and 20% per annum on the entire judgment sum until the sum is liquidated. On the 29th of November 2021, claimant opened his case, testified on oath by adopting his written deposition as his oral evidence. In this case, he tendered documents admitted and marked as Exhibit H to H9. He was subsequently cross-examined by Leonard's senior counsel on behalf of the defendant. Afterwards, he closed his case. Parties at some point tried to settle the matter amicably, which moved the court encouraged pursuant to Section 20 of the National Industrial Court Act 2006 and granted adjournments accordingly. However, settlement broke down irretrievably and parties had to resort back to status quo. On the 20th of January 2022, defendant opened its defense by calling DW11 Elijah Gabriel, a workshop assistant supervisor of the defendant who adopted his written deposition as oral evidence and through whom documents tendered and were marked as Exhibit E to E8. DW21 Hawa Usman, office assistant of the defendant, was equally led in her evidence in chief, but he didn't tender any document. Both DW1 and 2 were cross-examined by Leonard counsel on behalf of the claimant. On the 2nd of March 2022, DW3 Joy Belu, a subpoena witness, was put on oath and she tendered Exhibit Joy, that is, account opening package and account statement of G-Tech Engineering, which was the purpose of the subpoena. Afterwards, the case of the defendant was closed and the matter was adjourned for adoption of final addresses. Parties had actually filed their final addresses and have reduced that into the body of this judgment. So I'll now go straight to the decision of the court. I've given an in-depth consideration to the originating process together with the accompanying process. The statement of defense along with its accompanying processes and the final written address of parties in this case, I am of a humble view that the issues necessary for the determination of this suit are: 1, whether the suit of the claimant as presently constituted is competent; 2, whether or not claimant has proven his case to be entitled to the relief; and 3, whether the counterclaimant has proven its case to be entitled to the relief sought in the counterclaim. Respecting issue 1, Leonard's senior counsel for the defendant, Zibri Esquire ICN, in the final written address argued that the claimant's complaint is incompetent because the date stamped on the process shows that it was filed on the 20th of September 2021. The date on it shows that it was dated the 21st, which means that the process was filed undated. It submitted that the consequence of filing an undated writ is that the writ is invalidated, thus incompetent. As such, there is no competent writ before the court. Let me start by saying at the outset that whether an irregularity renders a process void or merely voidable depends on the type of irregularity. An irregularity which goes to the root of an originating process is fundamental. See the case of Heritage Bank Limited versus Bentworth Finance Nigeria Limited citation captured. In the instant case, it is clear that while the stamp on the general form of complaint shows that it was received by filing on the 20th of September, the actual date on the process is 21st of September 2021. A perusal of the accompanying processes shows that while the statement of facts, list of documents and list of witnesses are dated 17th of September 2021, the statement on oath is dated 21st of September 2021. I've equally taken judicial notice of the fact that the receipt of payment of filing fees at page 27 of the record of this court also shows that the filing fees was paid on the 20th of September 2021, which is the same date on the stamp and which lends credence to the fact that the process was actually for filing on the 20th day of September 2021. There is no doubt that 20th September, which was the date the process was presented for filing, predates the date on the process, which is 21st of September 2021. I agree with the position of Leonard Silk in the final written address that this raises the presumption that the process was filed on. However, it is important to correct some assertions made by Leonard's senior counsel in the final written address. I noticed that the Leonard Silk kept referring to the originating process in this case as quote and unquote writ. Let me remind counsel that in this court, a writ is not one of the modes of commencement of action unless or unlike it is in the High Court. See Order 3.1 of the National Industrial Court Civil Procedure Rules 2017. What we have in this court is the complaint, which is what claimant filed as shown from the record of the court. See page 1 of the record. Again, a particular assertion made by Leonard Senior Counsel at paragraph 3.3 of the final written address that claimant was the one that dated the complaint, a date after filing. A cursory look at the process clearly shows that the registrar of the court, one Balogun Olajide Registrar 1, did not sign the complaint until the 21st of September 2021. The import of this is that up to 21st day of September 2021, the originating process was still with the registry of this court until it was issued and served on the defendant. The signature of the registrar of this court, who stamped and dated the complaint on the 21st of September 2021, has authenticated the originating process. A court may presume the existence of any fact which it thinks likely to have happened regarding had to the common cause of natural events, human conduct, and public and private business in their relation to the facts of a particular case. See Section 167 of the Evidence Act, and the cases of Wande versus Bien and Orders citation capture, the case of Anyawu and Orders versus Uzowaka citation captured. The presumption that the general form of complaint was dated by the registrar, who was in possession of a process in his normal or common course of business, and not the claimant who has divested himself of possession of a said originating process since 20th of September, same to the registry for filing, is in favor of the claimant in line with Section 167 of the Evidence Act. The said presumption has not been rebutted by the defendant in this case, as there is nothing to show that it was the claimant or his counsel who put the said date after he had filed the process in court. Also, although, as argued by Leonard in his final written address, the question of jurisdiction can be raised at any stage of the proceedings in appeal. That jurisdiction is of two types, procedural and substantive jurisdiction. In the case of Kuri National Oil Corporation versus OPS Nigeria Limited citation captured, the Apex Court per Mohammed JSC held that whereas jurisdiction in respect of subject matter of the suit, otherwise known as substantive jurisdiction, is provided for by either the Constitution or the statute establishing the court, while procedural jurisdiction for initiating the suit falls within the precinct of the court's adjectival laws, the court went further. The non-compliance with procedural requirements for initiating an action by itself and irregularity in the exercise of jurisdiction should not be confused with total lack of jurisdiction. I must equally state that while procedural jurisdiction may be waived, substantive jurisdiction cannot be waived or conferred on the court by litigants. See the cases of Ostankino Shipping Company Limited and owners, the MT Bata 1 citation captured, the case of Bakari and Idigbe citation captured, case of Dangote Cement PLC and Zakirat citation captured, the case of Ndayako and Dantoro citation also captured. Thus, the question of procedural jurisdiction being not one of substantive jurisdiction cannot be raised at any stage of proceeding. In the case of Unity Capital Assurance versus Uzoku citation captured, the Court of Appeal per Agim JCA, now JSC, held inter alia those, and I quote, the question of the lack of jurisdiction of a trial court to entertain and try the suit due to the alleged incompetence of the originating process raised in ground 1 does not belong to the class of jurisdictional complaints that can be made at any stage of a case, even for the first time on appeal in this court or the Supreme Court. This is because it is a contention of lack of jurisdiction as a result of non-compliance with the rules of court, while questions of lack of subject matter jurisdiction and lack of territorial jurisdiction, lack of jurisdiction over parties and action being started bad are matters of substantive jurisdiction that can be raised in any manner and any stage of the case, even for the first time on appeal to this court, with or without leave. Questions of lack of jurisdiction due to non-compliance with rules of procedure in the initiation of a case or the cause of it are matters of procedural jurisdiction that cannot be raised in any manner and at any stage of a case. Such complaint must be made by a party during the trial before he or she takes any step in the proceedings after service of the relevant process and cannot be raised for the first time on appeal to this court or the Supreme Court without leave of court, which leave can be granted only where it is shown that the non-compliance has caused the complaining party injustice. See also the case of Kosen Nigeria Limited and Savannah Bank Nigeria Limited citation captured. The submission of Leonard Sake is on the jurisdiction of the court to entertain this suit because, according to him, the general form of complaint was filed, quote and unquote, undated process. Assuming filing the general form of complaint undated and putting the date subsequently by the court registrar before service of same is even something to raise an eyebrow against, it must be pointed out that the irregularity, if any, is one that touches on the procedural jurisdiction of this court and not on its substantive jurisdiction. In essence, what the defendant is challenging in this case is the procedural jurisdiction and not the substantive jurisdiction of this court, as I've stated. Thus, same should not be confused with total lack of jurisdiction by this court. A such same must be made during trial before the defendant takes any further steps in the proceedings after service of the originating process and not at any other stage. A party will be deemed to have waived the question of procedural jurisdiction where it takes a step further in the proceedings without challenging the procedural irregularity at the earliest opportunity. See the cases of Price Waters and Mormon citation capture, the case of the vessel MTC Tiger versus ASM HK Limited citation capture, the case of Zakirai and Muhammad Supra, the case of Nagogo and CPC citation also provided. In the instant case, the defendant, though entered conditional appearance, which ordinarily is an appearance under protest to object to the jurisdiction of the court, but it failed to file any objection to the jurisdiction of this court as expected by the conditional appearance. The filing of a memorandum of appearance, as was done in this case, without any objection to the jurisdiction of the court as expected, and the submission of the defendant to the jurisdiction of the court by filing its statement of defense, together with its accompanying process and also participating fully in the proceedings throughout trial, constitute a waiver of any irregularity and constitute a submission to the procedural jurisdiction of the court. The defendant submitted itself to the jurisdiction of this court by filing its statement of defense and claim, along with other accompanying processes, and also participated fully in the proceedings till trial was completed. This meant that it has waived the irregularity, if any, in the originating process, which it is now complaining of in its final written address, having not raised same timeously. It is too late in the day for the defendant to be raising the question of procedural jurisdiction for the first time in its final written address, having participated fully in the proceedings without any objection. The question that agitates the mind of the court at this stage is, assuming the objection of Zibiri SAN was even made timeously, and it is even the duty of the claimant to put date on the originating process, does the failure of the claimant to put same render the action of the claimant incompetent? Put differently, will the subsequent date put on the process after filing not cure whatever defect, if any, occasioned by the failure of the claimant to put date at the point of filing? In answering these questions, I will place reliance on the recent case of Solumadi and Kuti citation captured, the Apex Court per Agim GSCE, while considering the yardstick for the validity of originating process held entirely at those, and I quote, "The writ of summons had already been signed, sealed, and issued by the registrar of the trial court on the 5th of October 1998 after the plaintiff's application in Form 1. The writ was presented in the registry of the trial court for filing, and the filing fees assessed by the registrar paid. The writ of summons became a valid legal originating process once it was filed, signed, sealed, and issued by the registrar. Once the registrar of the trial court accepted the plaintiff's application in Form 1 for the filing and issuance of the writ of summons filed and issued it in spite of any defects in the application Form 1, a valid writ of summons comes into existence. The registrar has the prerogative power to refuse to accept or filing a writ of summons because of the omission or other defect in the Form 1 in which the application is made. But once he or she accepts it for filing, files, and issues same, the writ of summons becomes legally effective, unquote. Following the decision of the Apex Court in the above case, it is clear that once the writ hearing as general form of complaint has been accepted for filing by the registrar of the court, notwithstanding any omissions or defects, appropriate filing fees paid, and same was signed and issued by the registrar, the complaint becomes a valid legal document. In the instant case, although as stated supra, the process was presented for filing undated, it is a prerogative of the court registrar to reject same due to absence of date. And once it was accepted by him for service, despite absence of date, and same was assessed, and the appropriate filing fees was paid as seen at page 27 of the record, and which process was signed, subsequently dated, filed and issued by the registrar, Balog Bolajide, on the 21st of September 2021, the general form of complaint becomes a legally valid and subsisting process. The fact that the registrar accepted it for filing and the appropriate filing fees was paid, and the registrar, an officer of this court, put on the process the date on which he signed the process and then subsequently files and issues same. The defect, if any, of the absence of the date at the point of filing has been cured by the act of the registrar. In my humble view, whatever defect in the general form of complaint occasioned by the absence of the date at the point of filing has been overtaken by event of the subsequent act of the registrar as regards the filing of the general form of complaint. In any case, there's nothing in the rules of this court 2017 that suggests that it is the duty of the claimant or his counsel to put date on the originating process. The provisions of the rules, specifically Order 4, Rule 4, Sub-Rule 3, only provides the claimant or his counsel shall sign the originating process. Claimant or his counsel. In fact, the court in the case of Ngwagu and Ofiebu, citation captured, held those as regard filing of the court process. I quote, when the process is filed in the court, the appropriate fees, if any, must be paid. The registrar in charge of the court must affix the court stamp on the process and date same accordingly. All these are to obviate any rigmarole over date of receipt and actual receipt of same, unquote. In fact, in practice, when processes are presented for filing, the registrar is usually the one who dates same in order to obviate any argument as regard the date of receipt of the process, as in this instance, which is usually put on the process at the point of filing. In essence, the objection of the defendant hearing on the incompetence of the general form of complaint for absence of date at the point of filing is not only incompetent, but also lacking in merit. In view of the above and all stated hearing before, I find that the originating process of the claimant is competent before this court. Thus, question 1 is resolved in favor of the claimant. Now to question 2. It is expedient for me at this stage to address this contention of learned senior counsel for defendant as contained in paragraph 3.1.5 of his final written address, in this case as regards the written statement on oath of claimant. According to counsel, the said written statement on oath cannot be relied on by the court, having been stated by the claimant while under cross-examination that he deposed to them in his lawyer's office. It is true that claimant, while under cross-examination on 29th of November 2021, answered that he deposed to the written statement on oath in his lawyer's office. It is also true that deposition on oath and affidavit must be done before the person authorized to administer oath. However, it is now the law that deposition on oath of witnesses cannot be rendered invalid by mere reason of defect in the form the oath is taken. As such, it is not true that such defect will affect the validity of the evidence of the witness. I will now proceed to state why. The Supreme Court in the recent case of Idigbe and Aduloju citation captured, while considering whether defect in the form of an oath is taken or administered, held that Section 4, Subsection 2 of Oath Act provides that no irregularity in the form of an oath or affirmation is administered shall render inadmissible evidence in or in respect of which an irregularity took place in any proceedings. The court went further that by Section 4, Subsection 3 of the Act supra, the failure to take an oath or make an affirmation and any irregularity as to the form of an oath or affirmation shall in no case be construed to affect the liability of the witness to state the truth. According to the Supreme Court in that case, even if the first respondent written statement on oath in that case was not made on oath or sworn at all, it will still be valid as the witness written statement of oath in the proceeding, and nothing precludes the witness from adopting it as his testimony when testifying on oath in examination in chief in open court. See also the case of Sholola and the state citation captured, the case of Anatogu versus Iweka citation captured. The import of this decision of the Supreme Court is that any irregularity in the form of an oath is taken, which in this instance is the deposition of a statement of oath in the office of the Learned Claimant Counsel as against before Commissioner for Oath, which signifies that the statement was not sworn before the person authorized, will not vitiate the statement on oath once the claimant has entered the witness box and was put on oath while testifying in the open court and has adopted the statement on oath as his oral evidence in chief. The claimant in this case in his evidence in chief on 29th of November 2021 was put on oath and swore on Holy Quran to speak the truth and adopted his two written statements on oath as his oral evidence. Thus, whatever defect in the statement on oath occasioned by deposing the statement on oath in the law office of his counsel instead of before the Commissioner for Oath has been cured by the subsequent oath taking in the witness box and adoption of the statement as oral evidence in chief. Thus, the said statement on oath and additional statement on oath of the claimant in support of the statement of facts, an additional written statement on oath in support of his reply or defense to counterclaim, having been adopted by claimant in open court while on oath, are both valid and the evidence therein not affected. In addition to this, it is apparent on the face of the claimant's written statement on oath that it was deposed to by the claimant before the Commissioner for Oath of this court. That raises again a presumption of regularity. Thus, the objection of Learned Senior Counsel for the defendant to the two statements on oath is discountenanced, I so find and hold. Next is the case. The claimant in this case seeks declaratory relief, which is an equitable relief. It is a well-settled position of a law that declaratory reliefs are not granted as a matter of course, or even on admission of the adverse party. The claimant, in order to be entitled to the grant of such release, must rely on the strength of his own case and not on the weakness of that of the defendant. However, he may rely on aspects of the defendant's case that support his. See the cases of Ehile and Ikorodu local government citation captured, the case of Uzodima and Ihedio has citation captured, the case of Dikibo and John citation provided. Claimant V. Relief A is claiming that he is entitled to the sum of $30,000 at the rate of $1,500 per month from January 2020 till August 2021, which represents quote and unquote cost of living after completion of 6 months from joining date. As contained in paragraph 2 of the entitlement clause, which the defendant held in arrears from January 2020 to date, claimant averred facts relating to this relief in paragraph 3 of the statement of facts. The defendant read paragraph 4 of the statement of defense and counterclaim admits that by claimant's employment offer letter is entitled to the sum of $1,500 cost of living, but the same could not be paid to claimant from January 2020 to date since he breached his obligation to the defendant. It is the law that where parties have reduced the terms and conditions of service into writing by way of contract, the conditions must be observed. This is because the common law recognizes and protects the sanctity of contract. This finds expression in the Latin maxim, pacta sunt servanda. The position of the law as regards master-servant relationship is clear, as the law sees it as a contractual one governed by the terms and conditions of the employment contract. So the case of Oak Pensions Limited versus Olayinka, citation captured. As such, where the employer wishes to terminate employees' employment, he must do so in accordance with the contract entered into by parties. Say the cases of Organ and others versus Nigeria Liquefied Natural Gas Limited, citation captured. The case, Doriel's case of Lunga and First Bank of Nigeria, citation provided. The terms and conditions of employment between the parties as contained in Exhibit H, which is also Exhibit E. It is a well-settled principle of our law that civil cases are decided on the balance of probabilities and the evidential burden of proving the existence of a particular fact shift from one party to another as the scale of evidence preponderates. See the case of Union Bank and Ravi Abdul and Company Limited citation captured. Case of Olale and trustees of ECWA citation also provided. Claimant of the ordinarily has discharged the burden on him to prove that he's entitled to the said sum by tendering Exhibit H. However, it is worthy of note that the defendant even admitted this fact. There's no onus on claimant to prove what has already been admitted by the defendant as stated above, that by the contract, claimant is entitled to $1,500 cost of living since January 2020. Its only contention is that claimant has not been paid that sum since then to date because of an alleged breach. The onus then shift to the defendant to prove its own assertion and reason for the non-entitlement of claimant or failure to pay claimant. I'm mindful of the submission of the defendant in his final written address that the sum of $1,500 is a one-off sum and not a monthly sum. Let me state that parties, including their counsel, are bound by their pleadings and cannot set up a case different from its pleadings and address of counsel. No matter how beautifully written, cannot be a substitute for pleadings or evidence. See the case of Okeke and Inwi Gene, citation captured, Okoko and Dakolo, citation captured, Oyeyemi and Uweye, citation captured, and the case of Agbaruka and FBN Limited, citation provided. The defendant in its pleadings did not state that, contrary to claimant's claims in his statement of facts, that the said sum was a one-off sum, as learned counsel will want the court to believe in this case. The defendant in its pleadings stated thus in paragraph 4 of the statement of defense, and I quote, the defendant, in addition to the response to paragraph 3 of the claim, admits the claimant's employment offer letter contains that the claimant shall be entitled to the sum of $1,500 cost of living, but states that the claimant could not be paid the said sum from January 2020 to date, since the claimant breached his obligation to the defendant, unquote. The use of the phrase, quote and unquote, from January 2020 till date is a clear indication that the money was to be paid beginning from January 2020, and therefore cannot be a one-off sum, as learned counsel for defendant will want this court to believe. The wording of Exhibit H is clear as regards the fact that claimant monthly pay will be $5,000 plus $1,500 cost of living, payable after completion of 6 months from joining date. In effect, it means that the claimant's monthly pay will be $5,000, but after 6 months from joining date, $1,500 cost of living will be added to the said sum of $5,000. It's thus obvious that claimant beginning from 6 months after joining date, which in this case is 1st of January 2020, is entitled to an additional sum of $1,500 cost of living. The $1,500 is obviously an addition to the monthly pay of $5,000. Thus, if the monthly salary of $5,000 is paid monthly, the $1,500 will equally be added to it from when it falls due. It is clear from the content of Exhibit H, and as admitted by the defendant, that claimant by the contract is entitled to $1,500 monthly for cost of living, which is due for payment from January 2020. Therefore, I agree with the position of the claimant and learned counsel on his behalf in the final written address that the money is a monthly pay. The defendant, who is alleging that claimant was not paid due to the fact that there was a breach, has the burden to prove that claimant breached the terms of his employment. The defendant, through several paragraphs of the statement of defense and counterclaim, averred that claimant was in breach of its obligation to the defendant as contained in Exhibit H. Hence, he was not paid the sum of $1,500 living cost. It is expedient at this stage to reproduce the relevant terms and conditions of the employment relationship between parties as contained in Exhibit H. I quote, under obligations, during your employment, you shall devote your full business efforts and time to the employer. In addition, you shall not engage in or have any direct or indirect interest in a firm or corporation or business, whether as an employee, officer, director, agent, security holder, creditor, consultant, partner, or otherwise, that is competitive with the business of our company. 4, confidentiality and non-compete. The employee acknowledges that in the course of performing and fulfilling his duties, he may have access to and be entrusted with confidential information concerning the present and contemplated financial status, projects, and activities of the employer. Hence, employee agrees to retain such information as confidential and not to use said information on his own behalf or disclose same to any third party. Moreover, the employee hereby agrees not to directly or indirectly compete with the business of the employer and its successors and assigns during the period of employment and for a period of 3 years following termination of employment, and notwithstanding the cause and reason for termination. The term, quote and unquote, not compete, as used herein, shall mean that the employee shall not own, manage, operate, consult, or be employed in a business substantially similar to or competitive with the present business of the employer or such other business activity in which the employer is substantially engaged during the term of employment, unquote. The above portion of Exhibit H are clear and require no special aid to understand. The effect of the above 2 clauses are that they restrain the employee, that is the claimant, from revealing confidential information and to compete with his employer. It is not uncommon to have clauses like these in employment contracts. They are usually referred to as the restraining clauses, which are either quote and unquote restraint of trade or non-disclosure or non-compete clauses. Generally, covenants in restraint of trade are unenforceable. They can only be enforceable if they are proven to be reasonable in scope, nature, and content, and having regard to the interests of the parties and the general public. See the Apex Court decision in the case of Comolis and Leventis Motors Limited citation captured. It was held, thus in that case, generally all covenants in restraint of trade are prima facie unenforceable at common law. They are enforceable only if they are reasonable with reference to the interests of all parties concerned and of the public, unquote. This decision was followed in the later decision of the Court of Appeal in the case of Tank Sale versus Ruby Medical Center Limited citation captured. This court, per my humble self, in the case of Studio Press Nigeria PLC versus Ganesh Kador, and another suit number NICN/LA/144/2015, which judgment was delivered on 18th of March 2016, I held in that case that the first defendant to be liable in damages for breach of the contract of restraint of trade clause contained in his employment agreement with his former employer, the claimant after the claim. The employer, the claimant, after the claimant was able to successfully prove that the first defendant had breached that clause. In the same vein, this court in the case of the Market Research Consultancy Limited versus Mr. Pradikta Kumar Mitra and another is also an unreported suit number NICN/LA/532/2014, judgment delivered on 19th of January 2017, where Kanyip J, now the president of this court, held that although there was a non-disclosure, non-compete clause in the agreement between claimant and first defendant and India, the claimant failed to prove that the first defendant diverted its clients to the second defendant, its new employer. Thus, the first defendant was held not to be guilty of breach of contract. It is thus clear from the above decision of this court that it is the duty of a party asserting breach of contract to prove same in line with the fundamental principle of our law, that it is the duty of he who asserts to prove where the employer is able to successfully prove the breach of restraint clause in accordance with the law respecting its reasonability, nature, scope, and content, having regards to the interests of the parties and the general public, the employee will be held liable. I've reproduced above the provision of item 3 in Exhibit H, the contract agreement between parties, which is to the effect that claimant shall devote his full business efforts and time to the employer, and in addition, not engaging or have direct or indirect interest in any firm or business that is competitive with the business of a defendant. In my humble view, nothing in the said clause precludes the claimant from owning or establishing a business. The fact that Exhibit H states that he must devote his full time and business effort to the employer should not be stretched beyond limit to mean that claimant's 24 hours a day should be devoted to the business of the defendant. That will be in breach of his contract. In view of the provision of his contract that states that the working hours should be as per local labor law in Nigeria. The Labor Act does not envisage an employee to work more than 8 hours in a day. That does not mean that claimant cannot do any other thing apart from the defendant's business in 24 hours a day, which is his daily full time. Of course, claimant will reasonably be expected to have time to do other things for himself. In my view, what the clause, when read along with other parts of the agreement, means is that claimant should do what is expected of him as regards the business of the defendant and must not do anything to the detriment of the business of the defendant, and also not to use the working hours of the defendant, whether directly or indirectly, to do any other business apart from the business of the defendant. Exhibit H, which is the contract agreement, states that the working days and working hours of claimant will be as per local labor law, Nigeria, while work days will be 6 working days as per local law, Nigeria, and working hours is 8 hours working per day. This then means that claimant has 8 hours in every 6 days in a week to devote to the business of the defendant. I do not lose sight of the fact that claimant, while under cross-examination on the 29th of November 2021, categorically stated his working hours as from 7:30 a.m. to 6 p.m. a week, which obviously contradicts the content of Exhibit H. Excuse me. It is a well-settled principle of our law that oral evidence will not be allowed to contradict the content of a document. Just a minute, please. Sorry, please. I'll take that again. That does not mean that claimant cannot do any other thing apart from the defendant business in 24 hours a day, which is his daily full time, of course. Claimant will reasonably be expected to have time to do other things for himself. In my view, what the clause, when read along with other parts of the agreement, means is that claimant should do what is expected of him as the business of the defendant and must not do anything to the detriment of the business of the defendant, and also not to use the working hours of the defendant, whether directly or indirectly, to do any other business apart from the business of the defendant. Exhibit H, which is the contract agreement, states that the working days and working hours of claimant will be as per local labor law, Nigeria, while work days will be 6 working days as per local law, and working hours is 8 hours working day. This then means that claimant has 8 hours in every 6 days in a week to devote to the business of the defendant. I do not lose sight of the fact that claimant, while under cross-examination on the 29th of November 2021, categorically stated his working hours as 7:30 a.m. to 6 p.m. a week, which obviously contradicts the content of Exhibit H. It is a well-settled principle of our law that oral evidence will not be allowed to contradict the content of the document. Say the following cases: Ashaka Sem PLC versus Asharatu Mubashirun Investment Limited citation captured. The case of Hamidu and another versus Kaduna Electricity Distribution PLC and another citation captured. Thus, I believe the content of Exhibit H, which states that claimant's working hours is 8 hours working day, which is 6 working days. A restraint of trade. A restraint of trade clause, ordinarily to be enforceable, must pass the reasonability test as stated supra. Thus, they are prima facie unenforceable unless the employer can show that it is reasonable. And what is reasonable is a question of fact and depends on the circumstance of each case. See the following decisions of this court. Captain Fakal Shekwi versus Dana Airlines Limited on reported suit number NICN/LA/144 2015, which judgment was delivered on 18th of March 2016 per Obaseki Osage J, and the case of La Casera Company versus Mr. Pralad Kotapurath Kangadaran is also a reported suit number NICN/LA/53/2016 per Peters J. The obligation clause above in Exhibit H, which is a form of a restraint clause, cannot be interpreted to mean that claimant cannot do any other thing outside his working hours. That would be an unreasonable interpretation of the clause. Claimant, while under cross-examination, admitted being the owner of the said G-Tech company. He answered thus while under cross-examination, I quote, question, are you the owner of G-Tech? Answer, yes, unquote. The above clearly shows that truly claimant carried on the business known as G-Tech Engineering. In fact, he also admitted further while still under cross-examination that the company has an account in GTB, that is Guaranteed Trust Bank, to which is the sole signatory. The defendant had alleged, read paragraph 11 of the statement of defense, that claimant engaged his Nigerian co-workers who are on full-time basis to carry out his private business activities during their official working hours, such as sending one house man, who is DW2 hearing, and co-workers of the defendant to lodge checks in favor of G-Tech Engineering, and also tasking them to remove tools belonging to the defendant from the workplace. Claimant read paragraph 13 of his reply and defense counterclaim denied he ever engaged any of his office colleagues in any private business during official working hours, and neither did he send Hawa Usman to any bank to lodge any check, nor ask any of his co-workers to remove tools belonging to the defendant's company. I'm mindful of the fact that DW2 on record, Hawa Usman herself, has reiterated in her evidence while under cross-examination doors, and I quote, question, how did you know the claimant engaged in freelance service? Answer, he sent me to collect check from H-Medics for Unigas, but at times I received G-Tech checks. I called to confirm, and he said I should collect and pay into his GT account, unquote. I'm not oblivious to the fact that the defendant in this case tendered Exhibit E2, which contains pictures of 3 check leaflets of H-Medics in favor of G-Tech Engineering. The defendant pleaded the checks read paragraph 11 of the statement of defense. However, it is clear from the above paragraph that the defendant never pleaded that the checks being relied on were the ones which claimant allegedly sent Hawa Usman DW2 to lodge at the bank for him. They merely pleaded and brazenly relied on pictures of checks issued in favor of G-Tech Engineering without more. Exhibit E4, which were pictures of checks pleaded in the above paragraph, were not tendered through DW2, who stated that claimant sent her to lodge checks on behalf of G-Tech Engineering in the bank. DW1, through whom the pictures of the checks were tendered, did not state in his written statement that it was one of those claimant allegedly sent to lodge checks, and those checks contained in Exhibit E2 were the checks which he logged for claimant. In fact, DW1 did not speak to the pictures of the checks at all in his testimony as contained in paragraph 13 of his written statement on oath, which has already been adopted as his oral evidence in this case. It is clear from the testimony of DW1 in paragraph 13 of the statement on oath above that DW1, who tendered the pictures of the checks, did not speak to the said Exhibit E4 at all. Neither did he state that the pictures of the checks were the ones claimant sent Hawa Usman to lodge. It is worthy of note that DW1, whom the checks were tendered through, even stated us while under cross-examination, I quote, question, you said the claimant engaged in freelance gas services. Did you follow him to do such services? Answer, I did not follow him to carry out such actions, but I know he was doing it, unquote. DW1 never stated, unlike DW2, that he was one of those claimants sent to banks to lodge checks, or that he knew that claimant engaged in freelance gas services through the checks. If he knew through the checks, he would have stated that he knew through the checks claimant sent him or his co-worker to lodge in the banks. It is thus clear as crystal that DW1 has no personal knowledge of the checks in question. Even DW2 did not speak to the said pictures of checks. It is a settled principle of our law. The parties must demonstrate documents tendered by them. It is the duty of the party tendering the document to link the documents qua exhibits to the relevant aspect of the case to which they relate and to tender same through the appropriate witness. In the case of Baji and another versus Onche and order citation captured, the court per Sankey JCA held those, and I quote, a court can only act on evidence placed overtly before it and not on purported evidence contained in documents dumped on it, with the unreasonable expectation that it will proceed to carry out the work of counsel to ferret out the relevant evidence and apply it to the facts in the petition. Such documents remain closed and dormant until they are spoken to or demonstrated by witnesses who have firsthand knowledge of them in open court, and not just any random witness who was told about their contents, like PW1 in the instant case. Certainly, as pointed out by the Apex Court in several of its decisions, the judge is an adjudicator and not an investigator. Therefore, his job is strictly limited to that side of the divide that is adjudicating. He should not be drawn into the squabble between the parties, but should keep a safe and dignified distance from the dust of battle so that his judgment will not be beclouded in the process, unquote. See also the following cases: Usman and another versus Jubrin and others, citation captured. The case of Osundina and Awuyale, citation captured. The case of Ajayi and others versus Governor of Kwara State, citation also provided. The defendant ought to have linked the pictures of the checks with the relevant aspect of its evidence that they were the ones DW1 lodged for claimant, and as such, that they were the ones DW2 lodged for claimant, and as such, tender same through DW2, who will be deemed to have first-hand knowledge of them and have spoken to them. Documents, no matter their relevance, cannot speak for themselves without the aid of explanation by a witness who had first-hand knowledge of them. Failure of the defendant to state that the checks were actually the ones DW2 lodged and tender same through DW2 Hawa, who actually stated that she had dealings with H-Medis checks or making either DW1 or DW2s to speak to the said checks is fatal to its case. It is not the duty of this court to assist the defendant to do its case by helping it to link the checks with the relevant aspect of the case. Courts have been several times cautioned to desist from assisting any party to build up its case. The checks were not tendered through DW2, which will have meant that those were the checks claimant sent her to lodge. In the absence of any evidence to the contrary, the court cannot find any evidence in support of the fact that DW2 collected and lodged checks for the claimant during the office hours. Be that as it may, there is also no evidence before this court to show that claimant involved his co-workers in the private running of his business, or that claimant tasked the defendant's workers to remove tools belonging to the defendant from his business workplace, and as such, this court does not believe same. DW2 did not say that the claimant sent her to H-Medis to collect checks of G-Tech for him, but said that while she went to H-Medis to collect checks meant for Unigas, it as the defendant, in her words, I quote, "He sent me to collect check from H-Medis for Unigas, but at times I received G-Tech checks. I called to confirm, and he said I should collect and pay into his GT account." Clearly, claimant did not send DW2 to H-Medis to collect his checks for him, but she was there to transact business on behalf of his employer, Unigas, the defendant in this case. In fact, DW1 testified under cross-examination that he has never followed claimant to carry out any freelance business, but he knew he was doing it. Thus, there is nothing before this court to lend credence to the fact that claimant involved any other co-worker to lodge check or to remove tools belonging to the defendant from claimant's place of business as alleged. Now it is expedient to consider the second leg of the obligation, which is to the effect that claimant shall not engage in any business which is substantially competitive to that of a defendant counterclaimant. The above clauses contained in Exhibit H, also Exhibit E, do not seem to generally preclude claimant or defendant to the counterclaim from engaging in any other business. The above clauses are to the effect that claimant is restrained from engaging in any business, whether directly or indirectly, which is competitive or substantially similar with the present business of the defendant or such other business activity in which the defendant may substantially engage during the term of employment. It is thus clear that where claimant has been shown to engage in a business that is competitive or substantially similar to that of the defendant counterclaimant, claimant defendant to the counterclaim will be liable for breach of contract. The defendant alleged that claimant engaged in a business that is competitive with its business by establishing G-Tech Engineering, a business which is competitive with its, by virtue of the provision of section 131 to 133 of the Evidence Act. He who asserts the law is must prove. This is because a party who desires a judgment to be given in his favor on the basis of the existence of certain facts must prove that those facts exist. See the cases of Agbabi Aka and First Bank, PLC, citation captured. The case of Omajali and David and others, citation captured. Akimbadi and another versus Babatunde and others, citation captured. Darego and AG Leventis, Nigeria Limited and others, citation provided. Civil matters are settled on balance of probabilities, as I've stated earlier, whereby if the party discharges the burden of proving a particular fact, the burden shifts to the other party to prove its own assertion as directed by pleadings. As such, where a party fails to prove its own assertion, the burden would not shift to the other party. The onus of proving that claimant engaged in a competitive business with that of the defendant is therefore on the defendant counterclaimant, who is asserting same. Once it fails to prove his assertion with cogent and credible evidence, then it is bound to fail in its claims. In my view, it is not just enough for the defendant to prove that claimant formed the business name G-Tech Engineering. He has to go further to prove that the business done by that company is competitive or substantially similar to its own business, and the same was conducted during his working hours as asserted by it. In fact, nothing in the said clauses prohibits claimant from having any dealing with the custom of the company. It merely prevents him from engaging in any business which is similar and competitive with that of the defendant. It then means that claimant defendant to counterclaim can have business which has dealings with the customer of the defendant, provided the business done with such customer is not substantially similar or competitive with that of the defendant. Competition and being substantially similar is a question of fact, which has to be proved by evidence. Exhibit E2 clearly shows that checks were issued in the name of claimant G-Tech Engineering. Exhibit E1 also shows that the status report of G-Tech Engineering, a business name involving electrical engineering, mechanical engineering, and general contracts. The defendant counterclaimant, who would want this court to find that the business of G-Tech is substantially similar or competitive with its own, has failed to tender any evidence that shows that the object of its own business with which G-Tech competes with or is substantially similar to. The defendant did not even place any evidence before this court to show its scope of business from which the court can deduce the competition, or that the business of both companies are substantially similar. It's merely placed before the court the status report, Exhibit E1 of the G-Tech, which states that it is involved in electrical, mechanical engineering, and general contract as stated supra. The defendant has not pleaded or placed any evidence before the court to show that its business involves in electrical, mechanical engineering, or even general contracts. The defendant in this case, merely by paragraph 2 of his statement of defense, admitted paragraph 2 of the claimant's statement of fact, which state that defendant is involved in the business and distribution of liquefied petroleum gas, sale of liquefied petroleum gas networks. It has not placed any evidence before this court to show that claimant was actually involved in the business and distribution of liquefied petroleum gas, sale of liquefied petroleum gas networks, which it has admitted to be the business it does. Thus, the defendant has not placed any evidence before this court to show that claimant's GTech Engineering actually involved or carried out freelance gas services as alleged by it. The status report of GTech tendered by the defendant stating that GTech is involved in electrical, mechanical, and general contact, that alone is not sufficient to prove that claimant's GTech was involved in freelance gas services as alleged by it. It has to go further to show that claimant did in fact engage in the business and distribution of liquefied petroleum gas and sale of same as it does. I am mindful of the fact that claimant relied on tendered Exhibit H4, which is the memorandum of association of the defendant in proof of his own assertion in his reply that his business is not competitive with that of the defendant. However, it should be stated for the obtained time that the onus is on the defendant, who is asserting the positive that claimant business is competitive with it, to prove the alleged competition by placing before this court cogent, credible, and verifiable evidence, after which the scale shifts to the claimant to disprove it by proving his own assertion that there is no competition. Where the defendant has not proven its own assertion by credible and cogent evidence, the onus does not shift to the claimant. Failure of the defendant to place before this court any evidence showing that GTech actually does the business of distribution and sale of liquefied petroleum gas, which it has admitted is in its business, is fatal to its case. I find from the evidence and circumstances of this case that the defendant has not put any credible, cogent, and verifiable evidence before the court in proof of its assertion that GTech Engineering is a competitive business with its business. The scarce of evidence on the part of the defendant has weakened its assertion against the claimant, and thus the assertion cannot be sustained. It is thus discountenanced. Assuming, but I'm not conceding to the fact that the defendant has discharged the onus required of it and the scale has moved to the claimant. The scope of business of the defendant is clearly stated in Exhibit H4. Claimant, paragraph 6 of his reply to statement of defense has stated that what he did for HMedis is purely electrical, mechanical, and just refill of gas for refrigerators. A perusal of Exhibit H4, that is the defendant's memorandum of association, clearly shows that the defendant carries on the business of liquefied petroleum gas. See items 1, 2, 3 of clause 3 of Exhibit H4. It is worthy of note that the defendant in this case also front-loaded copies of invoices, which was allegedly issued by GTech Engineering. It has been held in plethora of cases that the court has the power to take judicial notice of its record and look through its file to make use of any document contained in it in order to do justice. The said invoices are at pages 78 to 82 of the record. A perusal of the invoices clearly shows that what claimant GTech was doing for its customers were clearly electrical and mechanical works, with only a few instances of refilling of refrigerant. Now, the germane question that requires an answer here is, can the mere fact that claimant refill refrigerator gases, which everyone knows is size, be said to be a competitive business or business substantially similar with that of a defendant who is involved in a large-scale industrial liquefied petroleum gas services? The answer is obviously in the negative. To hold otherwise would mean that this court is stretching the scope of the business of a defendant beyond what it is said to be in Exhibit H4. That cannot in any way be a competitive business with that of a defendant or a business substantially similar with that of a defendant who is involved in large-scale gas business. I cannot find any competition or substantial similarity between the business of the defendant and the business named GTech. I so hold. I do not lose sight of the environment of in paragraph 16, 19, and 20 of the statement of defense that claimant, as a result of the above allegations, was made to appear before a panel of inquiry before whom he failed to justifiably defend himself. Claimant viewed paragraphs 24 to 25 of his reply to statement of defense vehemently denied that a panel was set up against him. Claimant also reiterated this fact under cross-examination. DW1 in this matter answered under cross-examination also stated that there was a panel of inquiry set up to investigate claimant which he was a member of. I must say that oral testimony of DW1 without more is not enough to prove that there was a panel of inquiry and that claimant could not justify his actions before the panel. If truly there was a panel before whom claimant appeared and was confronted with allegations, the report or record of what transpired at the panel would have been placed before this court, and same would also have been pleaded. Besides, if truly claimant has appeared before a panel and could not justify himself, the defendant would not need to issue him the query as stated in Exhibit H, except if the query was issued before he appeared at the panel. According to paragraph 19 of the Statement of Defense, on the second day of August 2021, claimant was invited to the panel and he could not defend himself during the session of the panel. The defendant has stated that in response to claimant's letter, he was given another query on the 13th of September 2021. I cannot find any record of any first query before this court, contrary to what the defendant would want me to believe. In fact, both parties tendered only one copy of a query each, which is the query of 13 September 2021. See Exhibit H1 and E7. The defendant asserting that there was a first query given to the claimant should have tendered a copy of that first query. It is in the absence of any other first query issued to the claimant before this court, aside the one issued to him on 13th of September 2021, that I find and hold that the claimant was given only one query. If only one query was given to the claimant and which was just given on the 13th September 2021, clearly a month after the purported panel of inquiry, I am wondering which one comes first. Is it the panel of inquiry before the query? As stated earlier in this judgment, a court may presume the existence of any fact which it thinks likely to have happened regard being heard to the common cause of natural events, human conduct, and public and private business in their relation to the facts of a particular case. See Section 167 of the Evidence Act and the case of Wande and BM Supra, case of Anyanwu and others versus Zowaka Supra. In the common course of business and official transactions in the world of work, a query always comes before a disciplinary hearings or proceedings. The above assertion of a defendant is very hard to believe for the singular reason that it does not accord with practice of discipline of an employee to say that a disciplinary hearing will have been held before a query. In view of all stated and reasons supra, find that claimant has not breached the terms of employment of the defendant. I so hold.
As God pleases.
I've held that mere establishment of GTech engineering is not a breach of claimant's obligation, and the defendant has not been able to prove that claimant sent DW2 to lodge checks for his private business. I do not believe the assertion of the defendant because establishment of GTech engineering, which is the bone of contention and which the defendant believes was in breach of claimant's obligation, only happened in July 2020, as seen in Exhibit E1, the CSC status report tendered by the defendant. Besides, the joy clearly shows that it was not until the 29th of July 2020 that claimant even took steps to open an account for the said GTech. Claimant was long overdue to be paid his living cost of $1,500 per month, even before GTech came into existence, which the defendant failed to pay. In essence, claimant should have even been paid the said sum even before the existence of GTech. I am of the respectful view that the defendant does not intend to pay claimant the said sum because same has even fallen due since January 2020, before the said GTech engineering even came into existence. The defendant itself has breached the contract of agreement when it failed to pay claimant the sum of $1,500 cost of living beginning from January 2020 as stated in the contract, which was even before the existence of GTech engineering, which is the bone of contention here. In other words, the defendant failed in its obligation to pay for the claimant's cost of living as agreed under their contract, thereby breaching the terms of the contract since January 2020, 6 months before the claimant registered GTech engineering. It therefore does not lie in the mouth of a defendant to assert that the claimant has breached its contract. I wonder how the defendant expects the claimant to sustain himself in this kind of a situation. The defendant brought the claimant to Nigeria and agreed to pay him living costs of $1,500 monthly. He then failed in its obligation under the contract and now turned around to complain that the claimant has breached its contract. This is a case of a pot calling a kettle black. The import of defendant's action is that as of January 2020, the defendant had breached its contract with the claimant. Therefore, there ceased to be a contractual relationship between the two. The law is notorious that he who comes to equity must come with clean hands. I find the hands of the defendant herein as one smeared with iniquity and cannot thus deserve to drink from the well of equity. I strongly believe that the equity of our fathers at the village square, at the Idigbe Palace, at the Emir Palace, or the Oba's Palace will not view this case differently. The consequence of the defendant's failure to pay claimant's living cost of $1,500 per month from January 2020 is for the court to find and hold in favor of the claimant that is entitled to be paid the said sum in damages. Accordingly, Relief A succeeds. It is also claimant's claim that is entitled to be paid his salary for the month of August in the sum of $5,000, having been unduly placed on leave without pay by the defendant. Let me at this stage address the issue raised by Leonard Silk in the final written address on behalf of the defendant that this court does not have jurisdiction to entertain the issue of claimant $5,000 monthly salary to be paid in arrears because according to Exhibit H, the money is to be paid in Lebanon. And since this court does not have jurisdiction in Lebanon, it cannot entertain any issue as regards the said sum. While it is true that by the content of Exhibit H, claimant's $5,000 basic monthly salary is to be paid in arrears in Lebanon, there's nothing in the said Exhibit H to exclude the jurisdiction of this court in respect of claimant's monthly salary. I'll proceed to explain why. It is the accepted rule on the interpretation of any document, whether a will, contract, or law, that the document must be read as a whole and its parts interpreted in that light, and that an effort must be made to achieve harmony among its parts. No part of it must be read in isolation, and extrinsic words should not be read into it. See the case of Anelo and others versus Madru Aguna and another citation captured, Nigeria Army and Aminu Kano, citation captured, Agbare and Mimra, citation captured, David Mbani and Ibiabe Bosi and others, citation also captured. It's clear from the content of a said Exhibit H that is the contract of agreement that everything must be done in accordance to local law, labor law of Nigeria, and that the workplace is the company offices in Lagos, Nigeria. The service of the claimant to the defendant are rendered in Nigeria. The claimant resides in Nigeria and not in Lebanon. It should be stated as it is clear as crystal in Exhibit H that there is nothing in the said document that excludes the jurisdiction of this court as regards any part of the contract, including the basic monthly salary. In fact, the defendant which claimant works for is registered in Nigeria under the Companies and Allied Matters Act. This court has jurisdiction to determine the entitlement of the claimants, including the basic monthly salary. The only effect of the said clause is that the sum will be paid in Lebanon. The document did not state that it is a Lebanese court that has jurisdiction as regards claimant's monthly salary. Thus, such extrinsic meaning should not be given to it. In fact, as stated earlier in this judgment, the contract is clear to the effect that the business relationship between parties will be regulated as per the local labor law in Nigeria. Equally worthy of note is the fact that the agreement states that claimants' income taxes will be as per local labor law Nigeria. More so, claimant's place of work is Nigeria. This means that the income of claimant will be taxed under Nigerian labor law. The import is that the income of claimant is subject to taxation in Nigeria under the Personal Income Tax Act, Laws of the Federation of Nigeria 2004. If claimant's income or entitlement is subject to taxation in Nigeria, then it means any question as regards his income or salary can be dealt with by Nigerian court. If it were not so, then his income would not have been stated to be subject to income taxes in Nigeria. Learned Silk obviously misconceived the import of Exhibit H as regards claimant's entitlements. It is consequently discountenanced. As stated supra in this judgment, claimant averred that he was placed on a verbal suspension without pay for 1 month in the month of August 2021 by one Mr. Abdul Nasser Sabra, who is the project manager, for an allegation that he was engaging in separate business than the one he was engaged for. See paragraph 6 to 8 of the statement of facts. The defendant in response, via paragraph 10 to 16 of the statement of defense, alleged that the allegations were not false, as claimant ran his separate business, G-Tech Engineering, which is a competitive business, while under the engagement of the defendant, thereby breaching his employment agreement to devote full time and effort to the defendant's business and not engage in competitive business whatsoever. Also, that he engaged in his Nigerian co-workers to carry out his private business during the official activities, and also attempted selling its LPG tank and equally stole from it. However, it is worthy of note that the defendant throughout his pleadings did not specifically deny that claimant was placed on a verbal 1 month suspension in the month of August 2021. See paragraphs 5 to 9 of the statement of defense, particularly paragraph 9. The defendant, however, did not state specifically the length of the period of the suspension, and neither did it deny or state that the suspension was non-verbal, contrary to claimant's averment. This, to my mind, is a tacit admission that claimant was actually placed on 1 month verbal suspension as alleged by him. Besides, there is no evidence before this court to show that the suspension is non-verbal and for a period longer than 1 month, contrary to claimant's averments. In view of the state of pleadings and lack of any evidence to the contrary, I believe the assertion of the claimant that the suspension was a verbal suspension for 1 month without pay. I am not unmindful of the contention of the claimant in his pleadings, particularly his reply to statement of defense that the said Abdul Nasser has no right to suspend him because his contract of employment states that he shall report directly to the CEO and not him. It must be borne in mind that a company, being a natural person, can act through any of its officers. Claimant herein has not stated that the said Mr. Abdul Nasser is not an employee of the defendant, and he has not also stated that he's senior in rank to the said Mr. Abdul Sabir Nasser. He has not equally averred that the defendant was not the one who delegated Mr. Abdul Sabi to discipline him, being the one with the disciplinary powers. The law is on a firmer terra that an employer has a right, whether express or implied, to suspend an employee with or without pay or half pay, and this cannot be a breach of employee's right. See the following cases: notorious case of Lunga and FBN PLC, citation captures; case of Akinjo and University of Ilorin, citation capture; the case of Ayewa, the University of Jos, citation provided. It must, however, be noted that whether suspension will be with pay or without pay depends on the terms imposed by contract between parties. In the English cases of Marshall versus Midland Electric, citation captured, and Hanley and Pease and Partners Limited, citation captured, it was held that an employer cannot suspend without pay where there is no express or contractual right to do so. In Nigeria, the courts have also shared similar view that ordinary suspension of an employee does not deprive him of his benefits unless it is expressly stated to be so. In the case of Bamishile and NJC and others, citation captured, the court per Kekere JC, now GSC, held that suspension of an employee from work only means the suspension of an employee from performance of ordinary duties assigned to him by virtue of his office, and that Exhibit KB3 does not impose any terms of the suspension either on half pay or without pay. As such, the respondent in that case is entitled to his salaries and emoluments, fringe benefits, and other perquisites of office. See also the case of Folution Enterprise Bank Limited, citation captured. In the case of Mobile Producing Nigeria Unlimited versus Udo Supra, the Court of Appeal per Abadua JCA held inter alia thus. I quote, also in the instant case, there is no evidence before the trial court that there were any laid down condition between the parties stating clearly the right of the first appellant to suspend the respondent without pay. The first appellant did not tender through DW2 any document embodying such condition of service. What it amounts to is that the first appellant did not possess the right under the said contract of employment to suspend the respondent indefinitely without pay. Cheating on contract is very explicit on this, saying that there is no implied contractual right on the part of the employer to suspend the employees without pay or disciplinary grounds. For there to be no pay, it must be expressly stated in a contract agreement of the parties. See Cheating on Contracts, 25th edition, page 683, paragraph 3456, unquote. It therefore means that where there is no express power to suspend without pay, the employer has no such right. In the instant case, I peruse Exhibit H, which is also Exhibit E, which is the contract document, and it is clear that it does not impose any term of suspension, either on half pay or without pay. Exhibit H is the document that regulates the employment relationship between parties, and there is nothing in it that gives the defendant the power to suspend without pay. The implied right of the defendant to suspend does not give him the right to go outside the terms of the agreement entered into by parties. Parties cannot go outside the scope of the agreement entered into by them. Exhibit E does not state that suspension should be without pay. In the absence of the express term that suspension can be without pay, I find that claimant is entitled to be paid his salary for the month of August 2021, that he was placed on suspension as suspension in line with the abundant judicial authorities is only the suspension of the employee from performance of the ordinary duties assigned to him by virtue of his office. It does not include loss of benefit except where the contract permits such by an express provision in the contract, and that cannot be implied or imputed by either of the parties or the court. Claimant's monthly salary by virtue of Exhibit H is $5,000. Thus, claimant is entitled to be paid the sum of $5,000 as his monthly salary for August 2021. Accordingly, I find that claimants with the B and E succeed. It is equally the contention of the claimant that his employment is still valid and subsisting, same having not been validly terminated by the defendant. It is the averment of claimant vid paragraphs 8 to 13 of the statement of facts that upon allegations made against him, he was placed on leave without pay. And even after several efforts at proving his innocence, his salary has not been reinstated. Neither has he been called to resume duty, but has been kept in oblivion till date, which prompted him to cause a letter to be written to the defendant. The defendant on his part stated that upon the receipt of a letter sent by counsel on claimant's behalf, it caused another query to be sent to claimant's email, which query claimant responded to. See paragraphs 27 to 30 of the statement of defense. Claimant read paragraph 19 of the statement of birth that is still validly employed in the defendant's company since his employment has not been validly terminated. The defendant, in response by paragraph 34 of the statement of defense, averred that the claimant is put to the strictest proof of the existence of a valid employment till date. The Supreme Court in the case of Cameroon Airlines versus Otutu-Izu, citation captured, held that a traverse must be made either by denial or non-admission, either expressly or by necessary implication. An averment that the defendant will put the claimant to the strictest proof is bad, and as such, there must be a clear denial or non-admission. See also the following cases: Ali and Salihu citation captured, Dr. Taiwo and Adegboro citation captured, Okeke and Oru citation provided. It is worthy of note that DW2, while under cross-examination, on the 20th of January 2022, was asked the following questions. I quote, "Are you aware the defendant is not paying the claimant since he was stopped from coming to work? From coming to court?" Answer, "I'm not aware and will not know if he's still in the employment. I confirm paragraph 37 of my deposition," unquote. In the same vein, the following conversation took place between claimant and counsel for defendant under cross-examination on 29th of November 2021. And I quote, "In this question, your employment has not been terminated before you rush to court." Claimant answered, "They have suspended me, taking the key to my office and stopped me from operating the email, stopped my salary," unquote. I also take judicial notice of the fact that Exhibit H1, which was the query issued to claimant, was issued on 13th of September 2021. And there's nothing in it stating that claimant was further suspended. Besides, there's nothing before the court to show that the employment of the claimant has been terminated by the defendant. Hence, the question posed by the learned senior counsel for the defendant to the claimant during cross-examination. I am mindful of the submission of Leonard Sekat, paragraph 3.64 of his final written address on behalf of the defendant, that claimant employment offer letter is no longer valid and subsisting, as the claimant has breached the terms and obligation of the employment. Leonard senior counsel for the defendant seems to be blowing hot and cold in this instance. First, as capture supra under cross-examination, he put it to the claimant that his employment has not been terminated. And at paragraph 3.64 of the final written address, he argued that claimant's employment is no longer valid and subsisting because he has breached the terms of the employment. Leonard senior counsel for the defendant must be consistent in the presentation of his case. The law disallows a party from growing cold and hot at the same time. Such contradictory or unstable stance cannot be accorded any credibility. Just a minute, please. I need to drink water. Quickly. Leonard senior counsel, so sorry about that, please.
Okay.
Leonard senior counsel or the defendant must be consistent in the presentation of his case. The law disallows a party from being cold and hot at the same time. Such contradictory or unstable stance cannot be accorded any credibility. I've held that the defendant has not discharged the onus on it to prove that claimant has breached his terms of employment. Assuming claimant even breached the terms of employment, the defendant has the option to treat the contract as terminated and end the employment relationship by giving claimant a letter of termination, pay his salary in lieu of notice contemporaneously at the time of termination, or give him 2 months notice or salary in lieu as agreed in their contract. The defendant chose to keep the claimant with his feet hanging without termination or give him work to do. It means that the defendant was still treating the contract as subsisting. See the case of Mobil Producing Nigeria Unlimited versus Udo, Supra. The case of Advanced Transport, Maritime Transport, Nigeria Limited versus Ojuboli, citation provided. There is no evidence before this court to show that claimant's employment has been terminated to date as provided in Exhibit H. In fact, Denelstick alluded to the fact that claimant's employment has not been terminated, but that he is only under disciplinary actions, severally in his final written address on behalf of the defendant. In the absence of any evidence to the contrary, this court finds that claimant's employment offer letter dated 11 June 2019 is still valid and subsisting, having not been validly terminated by the defendant. It is worthy of note that due to the global evolving concept of trust and confidence in employment relations, the conduct of the employer may allow an employee to treat the employment as one that has been brought to an end. This concept is usually referred to as the concept of constructive discharge. See Sweet and Maxwell, 2016, page 290, and Simon Honeyball, textbook on employment law, 14th edition, Oxford University Press, 2016, pages 149 to 157. Indeed, in some jurisdictions, this concept has been codified. For instance, Section 95, subsection 1, paragraph C of the English Employment Rights Act 1996 explain the concept of constructive termination thus, I quote, the employee terminates the contract with or without notice in circumstances in which he is entitled to terminate it without notice by reason of the employer's conduct, unquote. See also section 186(1) of the South African Labor Relations Act, 1995. It is no longer in doubt that this court, by virtue of section 7, subsection 6 of the National Industrial Court Act 2006, hereafter called NICA, and section 254(c)(1), paragraphs F and H, and subsection 2 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, hereafter referred to as CFRN, is empowered to apply international best practices in labor relations and conventions and treaties ratified by Nigeria, as well as international labor standards. This court, in view of its power under NICA and the CFRN, as captured above, has imported the concept of constructive termination or dismissal or discharge to our corpus juris. This principle was applied by this court in several of its cases, such as Mohammed Hamza versus Dangote Flour Mills and others, on reported suit number NICN/ABJ/281/2020, judgment delivered on 22nd of February 2022, the case of Christopher Luca and Dangote Cement PLC and two others, on reported suit number NICN/ABJ/03/2021, Mr. Henry Enyo versus NTA Star TV Network Limited, on reported suit number NICN/ABJ/151/2019, judgment delivered on 22nd of March 2021. It is worthy of note that the Apex Court has equally embraced and affirmed this concept of constructive dismissal or termination of discharge in some decisions. In the case of CBN and another versus Aribo citation captured, the Supreme Court held that the involuntary resignation of the respondent in that case, following his indictment by a panel in an act of misconduct, amounted to constructive dismissal associated with misconduct. See also the case of Ilodibia Nigeria Cement Company Limited citation captured, where the Supreme Court affirmed the decision of a trial court that the indefinite suspension of the claimant amounted to constructive dismissal. It is therefore clear that the concept of constructive termination or dismissal or discharge has found its place in our employment and labor law. It is therefore obvious from the facts and circumstances of this case that the overt act of a defendant, coupled with the fact that the defendant in Exhibit H9 failed to renew claimant's rent in a official apartment, and the fact that the defendant has lodged criminal complaint against the claimant, as seen in Exhibit E8, that the defendant no longer wants to retain the service of the claimant, and that the employment relationship between parties have broken down irretrievably. Consequent upon the peculiar facts and circumstances of the case, as stated earlier, this court finds that the employment contract between parties has been constructively terminated with effect from the date of this judgment, which is the 13th of July, 2022. Thus, relief C succeeds only to the extent that the employment relationship between parties subsisted to the date of this judgment, which is today, the 13th of July, like I said, 2022. I so hold.
As the court pleases.
I will take release F and G together for the obvious reasons that they are related. It is claimant's claim that is entitled to his salary in the sum of 5,000 USD per month and cost of living in the sum of 1,500 USD per month, both from September 2021 to the date of judgment. Claimant in this case has averred in his pleadings his monthly salary and the sum claimed as cost of living. He has equally supported same with Exhibit H. Was submitted in final written address on behalf of the defendant. Claimant is not entitled to the said sum because he has not worked during those periods. The defendant herein admitted in its pleadings to retrieving the implements of work of the claimant. The defendant, even after claimant caused the letter Exhibit H8 to be written to it after he served the 1 month suspension and was not recalled to work, served claimant with a written query in Exhibit H1, also Exhibit E7. He did not suspend the claimant or address the status of claim, which claimant responded to on the same day. It is worthy of note that till 21st of September 2021, when claimant approached this court, he has not been placed on another suspension and has not been allowed to work. In fact, to the date of this judgment, the defendant has not terminated claimant's employment, as I've stated earlier, and placed him on any further suspension as found supra. Section 15 of the Labor Act, Cap L1 Laws of Nigeria, 2004, which law has been made applicable to contract between parties by virtue of Exhibit H, provides that wages shall become due and payable at the end of each period for which the contract subsists. That is to say, daily, weekly, or at such time as may be agreed upon. In the case of Adekunle and Western Region Finance Corporation citation captured, where the plaintiff was suspended from work on allegation that he was responsible for the loss of some money belonging to the defendant, he was subsequently charged with criminal offenses relating to loss, but was discharged and acquitted for lack of sufficient evidence. The defendant then purported to dismiss the claim and the plaintiff with retrospective effect from the date of his. The plaintiff in that case claimed the salary for the period of suspension and succeeded. Fatai Williams J. relied on the cases of Robel, Bronze and Metal Company and Voss, and Hanley versus Pease and Partners, where Roland J. said, I quote, employer has no implied power to punish the workman by suspending him for a certain period of his employment, contract subsisting all the time, unquote. He held that by merely suspending him from performing his duties, the defendant corporation has allowed the contract of employment to subsist during the relevant period, and it is not open to them to put an end to it respectively 28 months later. They cannot, in his view, escape liability for paying the plaintiff's salary during this period by dismissing him retrospectively. In the much later case of Mobil Producing Nigeria Unlimited and Odo Supra, the respondent, the employee who is alleging that his suspension from work was unlawful, null and void, among other things as follows: payment of spy allowance calculated at the rate of 52,000 naira monthly from January 2006 to date of judgment, payment of annual allowances comprising leave allowance of 100,000 naira, Christmas bonus of 26,000 naira from 2001 to date of judgment. At the conclusion of trial, the trial court entered judgment for the respondent and granted respondent claims. In appeal to the Court of Appeal, the Court of Appeal was considering whether the trial court was right to have awarded respondent claim for salary to the date of judgment, which the court viewed as special damages. Court of Appeal, while affirming the trial award of the above claims for salary from the date to judgment, held $8 and I quote, once the suspension declared null and void, the effect is that the respondent was always and still is the servant of the counsel. Please mute yourself. I don't know what there's a noise.
I apologize. I apologize, my lord.
Yes, just mute your system. Mute yourself so that. Let me see you, but just mute your system.
Yes, my lord.
Mute just the phone so that I can see, I can hear you, and I can go on with this.
Yes, my lord. I'll mute myself.
He held that by merely suspending him from performing his duties, the defendant corporation has allowed the contract of employment to subsist during the relevant period, and it is not open to them to put an end to it retrospectively 28 months later. They cannot, in his view, escape liability for paying the plaintiff's salary during this period by dismissing him retrospectively. In the much later case of Mobile Producing Nigeria Limited and Udo Supra, the respondent employee, who is alleging that his suspension from work was unlawful and null and void, claim, among other things, as follows. I've stated all that he's claiming. At the conclusion of trial, the trial court entered judgment for the respondent and granted respondent claims. On appeal to the Court of Appeal, the Court of Appeal was considering whether the trial court was right to have awarded respondent claim for salary till the date of judgment, which the court viewed as special damages. The Court of Appeal, while affirming the trial court award of the above claims for salary from the date of illegal suspension to judgment, held per Mokri JCA does, and I quote, once the suspension is declared null and void, the effect is that the respondent was always and still is a servant of the first appellant. In the circumstances, respondent is entitled to all his withheld earnings. The law is that a unilateral termination of contract does not terminate the contract. The case of Foyelo and NEPA was cited. It is tried that a servant is generally entitled to damages in the sum of a period of notice. In the instant case on appeal, there is no evidence that the respondent was served with any notice of termination and is not aware of the termination of his employment. The question then is, when will the duration of the notice start to run from the purpose of calculating damages? In the circumstances, the respondent is entitled to his full earnings up to the date of judgment of the lower court. That covers the sum of 4,368,500 naira, unquote. In the same case, the court per Abadwa JC at page 78 to 82, paragraph 6C, held inter alia doors, and I quote, on the award of a respondent remuneration as special damages, it is my view that since the respondent has not been served with any notice of termination of his employment, and this court having held that the first appellant had no right in law to suspend the respondent without pay unless it was expressly contained in the terms and conditions of his employment, the respondent is entitled to his monthly and yearly remuneration or allowances right from the date of issuance of the said letter of suspension to the date of judgment of the trial court. See Adekunle and Western Region Finance Corporation Supra, Olafimiha and Mwale Tech Limited Supra, unquote. Similarly, in the case of Udoha and another vessel, Silama citation captured, the Court of Appeal affirmed the decision of a trial court in a master-servant employment as in this present, that an employee who was not served with letter of termination was entitled to his salaries and allowances from August 2006 when he was suspended till judgment was delivered. I've held that the defendant has not terminated claimant's employment, and as such, the employment relationship still subsists. have equally held that the defendant has no power to suspend claimant without pay in view of the fact that same was not envisaged by contract between parties. Have equally found that claimant's verbal suspension was for only 1 month. In essence, claimant is still an employee of the defendant, and it cannot escape liability of paying his salary within this period when he has not been suspended or his contract terminated. More so, claimant was brought into the country by the defendant by facts before this court. And if the defendant is no longer interested in engaging him after the fallout of parties, he should have done the needful by terminating his employment as stated earlier, pay his return ticket back to Lebanon as contained in Exhibit H, but it failed to do so. The defendant has not acted right, cannot escape liability of paying the salary since it has decided to treat the contract as still subsisting by not terminating his employment and then keep the claimant in limbo. Claimant in this case even tried mitigating the losses by approaching the court as soon as possible when he finished serving the 1 month verbal suspension and was not called back to work. I am convinced that claimant is entitled to the payment of the said sums from September 2021 to the date of this judgment. Accordingly, reliefs F and G succeed. Claimant by relief H seeks for general damages. This court has in preceding relief G and H granted claimant's claims to his arrears of salaries and other entitlements from September 2021 to the date of this judgment. It is a submission of learned defense counsel that general damages cannot be granted to claimant having not shown evidence of loss suffered. Let me reiterate the position of the law here. The position of the law here that general damages can be granted in cases where breach of contract is established and it needs not be specifically pleaded or proved contrary to what learned counsel wants this court to believe. See the cases of UBM PLC and Ajabule and another citation captured, El Petroleum versus Uma and other citation provided, UBM Limited and Short Stocks citation captured. I've held that the claimant was entitled to be paid his 1,500 monthly living costs, which has fallen due since January 2020, which the defendant failed to pay even before the establishment of GTech engineering, and which in itself constitutes breach of contract. However, the question that needs to be asked is if it is equitable to still award general damages in this case when the court has ordered that claimant be paid the said sum and all his earnings during the period of suspension to the date of judgment. The court in the case of Mobil Producing Nigeria Unlimited and Udo Supra, Abadu JCA held us, and I quote, on the award of the 2 million general damages, the appellant's counsel argued that it must fail for being gratuitous as the respondent made no claim for such relief. Furthermore, this is a case bordering on master and servant relationship whereby the respondent has been suspended since 2001 without pay. The trial court rightly awarded the respondent his salary and allowances for the period of suspension under the head of special damages. The law is whereas employee can recover his remuneration within the period of suspension, he cannot claim in addition to the sum due general damages. He's only entitled to what he would have earned throughout the period of suspension, which was never authorized by the conditions of his employment. The law is that where an employee is not paid for a period of employment in respect of which is entitled by the contract to be paid a fixed amount, his claim is not one for damages but a debt, namely payment for an agreed sum, since he is entitled to be paid according to the agreed rate. The employee cannot claim in addition to the sum due damages for delay in paying the salary. Also, a plaintiff who has been adequately compensated under one head of damages cannot claim damages under another head in respect of the same claim. It is tried law that the award of general damages is improper when the quantum of loss is ascertainable as it will amount to double damages or double compensation, unquote. Placing reliance on the above decision, I find that granting the relief for damages after the claimant's relief for salaries has been granted will amount to double compensation, which the courts have been enjoined to refrain from. See the case of MTN Nigeria Communication Limited and CSOCA Nigeria Limited citation captured, UBA PLC and Gostar Investment Company citation captured. In view of the foregoing, relief H fails. Claimant by relief L I, is asking for the sum of 2 million naira as cost of action. In the case of Kappa and Alberto Nigeria PLC and NDIC citation captured, the Apex Court held that a successful party is entitled to costs which he should not be denied except where he misconducts himself. See also the case of Sebi and allowable citation captured. It is a submission of Leonard Sick in paragraphs 3.76 and 3.77 of his final written address while relying on the Court of Appeal case of DHL International Nigeria Limited and Lazy Ozo Amaka Supra. The claimant is not entitled to cause of action because he was not pleaded or proved. In essence, Leonard Sick is taking the view that cause of action is some kind of special damages that needs to be specifically pleaded and strictly proved. Let me say that cannot be the current or extant position of the law. And I beg to differ from same because the Supreme Court has supported this view of cost of action in the case of Mequinye and Emirates Airlines citation captured, which was cited, Supra, which was cited by claimant in his final written address when the court held per Odili GSC now retired while relying on Order 25, Rule 7 and 2 and 7 of Federal High Court Civil Procedure Rules 2009, that it is clear that the power conferred on the court under the legislation in awarding costs is discretionary and not based on pleading of the parties or strict rule before the court determines whether or not to grant same. It is thus that the Court of Appeal was wrong to have held that the award of costs by the trial court amounted to granting special damages not proved, and that the discretion of the trial court in awarding costs is one where the Court of Appeal in that case ordinarily ought not to interfere with except and unless the award is manifestly excessive or too low. The rules of this court, particularly Order 55, Rules 1, 2, 3, 4, and 5, just like that of the Federal High Court, empowers the court to grant cause of action at its own discretion. The discretionary power of the court is to be exercised judicially and judiciously. In view of the fact that claimant has succeeded in almost all the relief sought, except one, I am of the firm view that is entitled to cost. I thus award the cost of 100,000 naira in favor of claimant. Now to issue 3. It is the claimant's counterclaim. It is the defendant's counterclaim that the act of claimant registering and establishing a business entity known as G-Tech Engineering while under the active employment of the defendant is in total violation of the obligations owed the defendant. The law has become ensconced that a counterclaim, though filed in the same suit and probably from the same transaction as that of the main suit, is a separate and independent action from the main claim, and as such, must be proved by the counterclaimant. Say the cases of Kolade and others of Ogundokun, citation captured, Oroha and others of Sardini and other citation provided, Oglioko Memorial Farms Limited and another versus NACB Limited and another citation captured. It is a weapon of defense which enables the defendant in the main claim to maintain the claim against the claimant. Thus, same is governed by the same rule of pleadings as the main action. Just as it is with the main action, it is the duty of he who asserts to prove. Thus, the burden of proof rests squarely on the counterclaimant to prove its case on the balance of probabilities. See the following cases: Tropical Culture Limited and another versus Akiola, Anwadike and another versus Anwadike and others, citation provided, Ulam and others versus Osman, citation captured. Thus, it is the duty of a defendant counterclaimant to prove its assertions in the counterclaim to the satisfaction of the cause before it can be entitled to judgment. The defendant counterclaimant by Relief A seeks a declaration that by virtue of the employment offer letter dated 11th of June 2019, the claimant is an employee of the defendant. The law is of common that declaratory reliefs are granted at the discretion of the court, but that discretion must be exercised judicially. This implies that all relevant facts that will affect the withholding of the discretion of the court to make the declaration are properly canvassed and placed before the court for consideration. The discretion cannot rightly be based on facts or circumstances which have not been submitted by parties to the court, but which the court on its own has restlessly fathomed out, outside the issues raised by the pleadings. Accordingly, the discretion to grant declaratory reliefs must be borne out of facts averred or issues raised in the pleadings of parties, and as such cannot be based on facts which were not averred. So the case of Adioye and Adekoke and other citation captured. This is in line with the SCON's principle of law that parties are bound by their pleadings and the party is not allowed to set up a case different from the one it has made in its pleadings. See the case of Abida Kun and others, Zoe Body and other citation captured. The court held that what the learned trial judge, in the case of Abida Kun and others, Zoe Body and others, the court held that what the learned trial judge required in law was to be satisfied by the pleadings and evidence of the appellants that they were entitled to the declaratory rights they sought. As such, he must rely on the strength of his own case as made out in its pleadings. The defendant counterclaimant who would want this court to make a declaration in its favor that claimant is its employee is the same person who denied read paragraph 2 of the statement of defense that the claimant's paragraph 19 of the statement of facts that is still invalid employment of the defendant. The defendant counterclaimant equally averred in paragraph 34 of the statement of defense that claimant is put to the strictest proof of the existence of valid employment to date. Both paragraphs 2 and 34 of the statement of defense of the defendant, wherein it refused to admit the existence of a valid employment with the claimant to date, have been incorporated as part of the counterclaim by virtue of paragraph 36 of the counterclaim. The defendant cannot, on one hand, be denying that claimant still has a valid employment with it, and be seeking a relief before this court to declare that claimant is still its employee. This court, as stated earlier in this judgment, will not allow the defendant act like a wave of the sea that is driven and tossed by the wind, blowing from left to right, and unstable and inconsistent in the presentation of its case. Declaratory reliefs can only be granted when the court is satisfied that, taking into account all the circumstances of the case, the claimant is fully entitled to them. The court is still not bound to make a declaration once it does not consider it proper in its discretion to make one. Mr. Okwozo, we need to see your face.
Lord, my Lord, I profusely apologize. I'm not Zoom tech savvy. I apologize, my Lord. I'm battling with the device. Okay. I apologize, my Lord.
Audio. You will see audio. Just on the audio so that there won't be any distraction. Your video should be on. You can click on the yes, you are okay. You are okay. The defendant counterclaimant has not convinced me by its pleadings that it's entitled to the relief sought. Relief A in the counterclaim is refused on the ground that the defendant counterclaimant has not justified its entitlement because its pleadings does not support same. I so find and hold. It is equally the contention of the defendant counterclaimant that claimant defendant to counterclaim committed fraud against it. It averred vid paragraphs 37 and 40 of the statement of defense counterclaim that the claimant had posted the LPG tank belonging to the defendant on an online market with an intention to sell same without the consent of the defendant counterclaimant. It equally averred that claimant stole from it some certain items particularized in paragraph 40 of the statement of defense counterclaim. The defendant counterclaimant gave particulars of the said fraud and stealing in paragraph 40 of the counterclaim, claimant defendant to counterclaim in response, be paragraph 45 of the reply of the statement of defense to counterclaim vehemently denied the averment of the defendant and stated categorically that the defendant instructed him to carry out a market and technical survey and build a report on the various reports the company may wish to engage in. The market traction in reference of demand for the said products, comparative analysis with competitors. By virtue of the fact that the company was yet to commence business on the said products, he put his personal phone number. In support of this, he relied on and tendered Exhibit 86. The defendant counterclaimant, in response, bids its reply to the claimant's defense to the counterclaim, specifically denied in paragraph 2, ever asking the claimant to embark on any market comparative analysis. It alleged that the said emails herein as Exhibit 86 were fabricated as they do not emanate from it. Claimant defendant to counterclaim equally denied via paragraph 53 of the defense to counterclaim that he never passed off the defendant's LPG tank. He also denied the allegation of stealing via paragraphs 47 to 50 of his reply to the defense to counterclaim. The defendant counterclaimant also contended that claimant's averment as regards the allegation of stealing. See paragraphs 4 to 11 of the reply to claimant's defense to counterclaim. The law is firmly settled that allegation of fraud in pleadings is an allegation of crime which must be specifically pleaded and established beyond reasonable doubt. See the following cases: Talek Drugs Company Limited and Onankwa, citation captured. Biko Nigeria Limited and another vessels, Electronic Connections Limited, citation provided. The case of Bitunde and Onyenson Community Bank Limited, citation captured. Thus, it is clear that the onus is on the defendant counterclaimant of crime against the claimant defendant to counterclaim. The defendant, in support of his assertion, tendered Exhibit E3, E4, E6, and E7. Let me at this stage address the admissibility and weight to be attached to some of the exhibits tendered by the defendant. Moreover, if this will not amount to raising the issue of their admissibility so modo and resolving same so modo. But then, it must be borne in mind that it is the duty of the court to act only on legally admissible evidence, whether the other party objects or not. Where the adverse party who is supposed to object fails to do so, the court is empowered to reject such evidence as proprio motu. See the following cases: Benjamin and Kalio, citation captured. Shitu and Fashawe, citation provided. Agash and Bulama, citation also provided. This court, being a court of law, owes this duty irrespective of whether the claimant, defendant, or counterclaimant raises the question of inadmissibility or not, because the court is only to rely on admissible evidence. The defendant tendered Exhibit E to E8. I've gone through the whole of the exhibit with the finery of a tooth comb. Exhibit E4 is a DVD. There is no doubt that Exhibit E4 is computer-generated evidence under Section 84 of the Evidence Act 2011, hereafter called EA. The Supreme Court, in the case of Dixon and Silva, Penway the JSC held us, and I quote, as shown above, the DVD in question was admitted in evidence as Exhibit P42B. In actual fact, Section 84 Supra consecrates two methods of proof, either by oral evidence under Section 84.1 and 2, or by a certificate under Section 84.4. In either case, the conditions stipulated in Section 84.2 must be satisfied. However, this is subject to the power of the judge to require oral evidence in addition to the certificate, as the lower court rightly observed, when it is an electronically generated document which has been admitted in evidence upon fulfilling of all preconditions, and it is not taken as read by consent, then it ought to be demonstrated or played to prove the facts alleged. Otherwise, it remains a closed or sleeping document which is unusable and which need not have been brought before the trial court or tribunal in the first place, as it would merely amount to clutter. I entirely endorse this view. The application to play the DVD had nothing to do with its admissibility. In any event, at that stage, it was already in evidence. It rather rests on an entirely different juridical postulate, which this court explained in Abga versus Amakura, citation captured, Okereke and Umahi and others, citation captured. According to this court, Penweze GSC, in Abga and Al-Makura Supra, pages 343 to 344, this prescription that parties have a duty to link their documents with their averments in their pleadings rests on the adversarial nature of our jurisprudence, which we inherited from the common law. It is therefore the impregnable juridical postulate of our adversarial jurisprudence that prohibits a judge from embarking on an inquisitorial examination of documents outside the courtroom. A fortiori, it is anathema for a judge to be allowed to act on what he discovered from such a document in relation to an issue when that was not supported by evidence or was not brought to the notice of the parties to be agitated in the adversarial procedure. The authorities on this point are many. In effect, although a document produced from a computer may cross the admissibility threshold in section 84(1), 2, and 4, it may still not be accorded the requisite weight if the quote and unquote accuracy conditions in section 34(1)(b), 1, 2 are not complied with. This then underscores the cogency demonstrating such documents like Exhibit P 42B in open court, so as to afford the proponents of such a document the opportunity of not linking them with their averment in their pleadings and evidence on records. Abga versus Amakura Supra, Okereke versus Umahi and others, but more importantly, with a view to discharging the requirement which will facilitate the court's attachment of weight to them. On the other hand, their demonstration in open court will equally afford the opponents the opportunity of testing and contesting the accuracy in the usual adversarial method of cross-examination, unquote. See also the following cases: Chukwuekere and INEC and others, citation captured; Kuba and another versus Dixon and others, citation captured. It is thus clear from the above authority that a DVD being a computer-generated evidence to be admissible must satisfy the condition of admissibility as contained in section 84, subsections 1 or 2 of the Evidence Act. In essence, the computer that was used in producing the DVD must be certified either by oral evidence or by a certificate in line with section 84(4) of the Evidence Act. After it scales the hurdle of admissibility, it must at some point be examined by demonstration in the open court, which is usually by playing same at some point, else it will just remain a dormant or sleeping document because the court has no duty playing the said DVD outside the courtroom, as this will amount to scouting for evidence for a party. In the instant case, none of the above was done as regards Exhibit E4. The defendant herein only made certificate of compliance in respect of Exhibit E1, E2, E3, E6, and E7. There was no certificate of compliance in respect of Exhibit E4. Neither was the fact contained, excuse me, in Exhibit, the fact contained in section 84(2) of the evidence that stated in the oral evidence of DW1 through whom the said Exhibit E4 was tendered. The defendant did not equally apply to demonstrate the said DVD in the open court. I am mindful of the provisions of section 12 of the National Industrial Court Act 2006, hereafter referred to as NICA, which enjoins this court to apply the Evidence Act, but in appropriate circumstances depart from its provisions in the interest of justice, and which provision was affirmed by the appellate court in the recent decision of the Court of Appeal, Ilorin Division in Mr. Victor Idigbe and United Bank for Africa, on reported appeal number CA/IL/20/2021, judgment delivered on 14th of April 2022. However, it should be noted that while the requirement of certificate of compliance in section 84 of the Evidence Act governs admissibility, which this court may decide to depart from, the requirement for demonstration of DVD in open court by playing it relates to the probative value to attach to it. Thus, assuming that the DVD Exhibit E4 was even rightly admitted in line with Section 12 of NICA, it will still be of no evidential value to the court in view of the fact that it was not demonstrated in the open court. It is not the business of this court to do cloistered justice by inquiring into the content of DVD when same has not been demonstrated in the open court for both parties and the court to see. This court, for the above reason, does not find it appropriate in this case to apply Section 12 of NICA because it will still not serve the purpose for which it was meant to serve. In essence, the said Exhibit E4 is not only inadmissible, but also lacks probative value. I so find and hold. I am mindful of the submission of his claimant's counsel, Mr. Okwozo, in paragraph 5.8 of the final written address that Exhibit E8 is not admissible for being caught up with the doctrine of lis pendis in line with Section 83.3 of the Evidence Act, because it was during the pendency of this suit. I must first state that the proper time to object to admissibility of a document is at the point the document was to be tendered, as stated earlier in this judgment. On the 20th of January 2022, when Exhibit A8 was tendered through DW1, learned claimant counsel was recorded saying he had no objection to any of the documents. It is too late in the day for him to start raising same now. But then the court has a duty to act only on admissible evidence, as I've stated earlier. It is true that Exhibit E8 was produced during the pendency of this suit. However, it should be noted that Section 83.3 of the Evidence Act does not seek to render inadmissible every document that was made in anticipation or during the pendency of the suit. The determining factor is if the maker of such document is a person interested. The disqualifying interest is personal, not merely interest in an official capacity, where, however, the interest of the maker is purely official or as a servant without a direct interest of a personal nature. There are decided cases that the document is not thereby excluded. The nature of the disqualifying interest will depend upon the nature of duty undertaken by the servant, where from the nature of the duty, the maker can be relied upon to speak the truth and that he will not be adversely affected thereby. The document has always been admitted in evidence. See the following cases: B.B. Akugo and Sons versus OHMB, citation captured. Case of Olomo versus Akbe, citation captured. High Grade Maritime Services versus First Bank, citation captured. The said exhibit was prepared by Leonard Silk, hearing on behalf of the defendant, and which was in official capacity as a lawyer of the defendant, who is an interested party. The learned counsel's interest in the suit as the lawyer of the defendant is in substantial respect congruous with that of his client, the defendant. Judicial authorities are all in agreement that the court has a duty to admit only admissible evidence as stated supra. But where it inadvertently admits inadmissible evidence, the court must at the stage of judgment treat same as if it has never been admitted, and same must be expunged from its record. So the cases of Ikezu versus Okonta, citation captured, Agbola and the state, citation captured, Abubakar and another versus Joseph and another, citation captured. Exhibit E4 and E8 are thus expunged from the record of this court. I so find and hold. I've gone through the exhibit tendered by the defendant, counterclaimant, in proof of the allegation of fraud against the claimant, particularly Exhibit E3. From the perusal, it is clear, as admitted by claimant defendant counterclaim, that he truly posted an LPG tank on the said online platform, GG. In fact, claimant reiterated under cross-examination that he was one of the contractors of GG and did marketing survey. Hereunder reproduced is the question and answer of claimant. I quote, "Do you know any online outfit called GG Online?" Claimant answered yes. Question, Who are the contractors of the company? Claimant, I did. We do marketing survey, unquote. The only contention of the claimant, as stated supra in his pleadings, is that he was doing that in pursuance of an instruction given by the defendant to conduct comparative market analysis in support of which he tendered Exhibit H6. The defendant counterclaimant on its part denied this assertion and contended that the email correspondence, that is, Exhibit H6, was fabricated and does not emanate from it. The court in the case of Nwoye and FAN, Supra, per Sanusi GSC, held inter alia, thus, and I quote, it is worthy of note that when the documents admitted as Exhibit MNOPQ were tendered at the trial, the appellant did not challenge the authenticity or existence of those exhibits. That being so, it would not be necessary for the respondent to tender them through the maker. There's no gainsaying that they said 5 letters, that is, Exhibit MNOP and Q, were pleaded in the defendant's statement of defense, even though they were not tendered through the maker, but through DW1. In my view, the trial court was right in overruling the objection of the plaintiff on the ground that DW1 was not the maker or author of the said letters, that is, exhibits, since the authenticity was not in question or challenged by the appellant, and the court below had rightly held that the appellant's complaint on the admissibility was too late, unquote. It is clear from the above that a party who wishes to challenge the authenticity or existence of a document should do so when the document is sought to be tendered. The defendant who would want this court to believe by its pleadings that the said emails are, as contained in Exhibit H6 was mere fabrication, therefore impugning on the genuineness and authenticity, did not raise any objection to the admissibility of the said exhibit. In fact, all the documents that were admitted through claimant on 29th of November 2021 were tendered and admitted without objection. The said Exhibit H6 is not rendered inadmissible by the law as it satisfies the conditions provided for in Section 84 of the Evidence Act because it was accompanied by a certificate. It is the law that a document which has not been challenged in any manner pejorative to its integrity and authenticity must be believed and acted upon by the court. See the following cases: Ilondu, and Ilondu, and another citation captured. Guacham and Ilondu, and another citation also provided. I am mindful of the submission of Leonard Slick in paragraph 3.4 of the final written address that companies carry out communication with the aid of internal memos, and there is nothing before the court to suggest such instructions. While it is agreed that organizations like companies give instructions through internal memos, however, I do not agree that internal memos is the only means by which communications is effected in companies or organizations. Any means that is known within the organization can be used to communicate. In fact, in this modern digital era, the use of electronic means of communication like email has now come to be accepted as means of communication even in corporate organizations. The important thing is that the mode must be one which is regularly used within the organization and one which officers are familiar with. The question that agitates the mind of the court at this stage is the use of electronic mail one of the means of communication in the defendant? In answering this question, I would like to make reference to paragraphs 14 to 16 of the statement of facts where claimant pleaded that he was given query by Abdul Nasser Sebra on the 13th of September, which query was sent through email of abdulnasser.sabra@unigas.net, and to which he responded to by email. The said query and its reply together with its certificate of compliance is herein admitted as H1. The defendant in its pleadings, read paragraph 29 of the statement of defense counterclaim, admitted sending query to the claimant by email The defendant tendered the said query on its own part as Exhibit E7, together with its certificate of compliance. The certificate of compliance stated categorically that the said query is an electronic printout of an email correspondence produced from the office computer. It is thus funny that the defendant, who had admitted sending a query to claimant by email in his pleading, is still the same person maintaining in the final written address that the only mode of communication in that company is internal memos. The submission of learned senior counsel for the defendant on this ground is hereby discountenanced. Wow, sorry, my battery is low. I'll proceed. The facts pleaded by claimant defendant to counterclaim as regards the email IDES Exhibit H6 were equally reiterated in paragraphs 47 and 55 of his additional written statement on oath, which was already admitted as part of his oral evidence in this case. The defendant did not equally cross-examine the claimant on the issue on the fabrication or authenticity of Exhibit H6. It is tried that failure to cross-examine a witness on the material point is a tacit admission of what is stated. See the following cases: Okegbe and others versus Akpome and others, citation provided; Akuja and another versus Kwandi and others, citation captured. The failure of the defendant counterclaimant to cross-examine claimant on Exhibit H6 is a tacit acceptance of the truth of it. I perused the said Exhibit H6, and I find in it that truly there were exchange of email correspondence between claimant and one Mr. Abdul Nasir Sebra, whom parties have stated severally in their pleadings as an officer of the defendant on market survey for LPG stations. Of particular importance is the email correspondence sent by the said Abdul Nasir Sabra from his email, quote, abdulnasir.sabra@unigas.net, unquote, to claimant on Monday, December 2nd, 2019, wherein several links were sent to claimant, including that of the said online platform, GG, as https://gg.ng/247 LPG-tanks/gas, unquote, and quote https://gg.ng/car-parts and accessories/LPG, unquote. I find that the said email is the same email that was used to send claimant's query in Exhibit H1 as stated in its certificate of compliance. And the defendant in this case has admitted that the said query was actually sent by email. It is obvious in this case that the defendant had always used email to communicate to the claimant, e.g., is also the email dated 20th of October 2021 sent by the same Abdul Nasir Sabra on the 27th of October, stating that the defendant would no longer pay claimant's accommodation cost. As reason supra, the defendant at the point of tendering this exhibit did not challenge its authenticity or existence, but allowed the document to be tendered without objection. In the absence of any other compelling contrary evidence, I'm inclined towards believing the assertion of the claimant that posting the said LPG tank on GG was part of a marketing survey he was asked to do by the defendant. In view of the above findings, I'm of the humble view that the defendant counterclaimant has failed to prove the allegation of fraud by passing off against the claimant defendant to the counterclaim. Really B also fails. The defendant counterclaimant read Relief C seeks the declaration that claimant breaches obligation to the defendant. I've held supra that the mere fact that claimant established GTED engineering is not a breach of his obligation. I've also found and held earlier that the defendant had indeed breached the contract since January 2020 when it failed to pay claimant living costs, which is an agreed term of the contract. I've also held that claimant will be in breach of his obligation if he's shown to use his official and business time with the defendant counterclaimant, whether directly or indirectly, to do any other business apart from that of the defendant. In the same vein, I've held that there is nothing before this court to show that claimant actually sent DW2 to the bank during working hours. In fact, the burden created by the counterclaim, being a declaratory one, is higher, as the defendant has to rely on the strength of its own case and not on the weakness of the defendant to the counterclaims. The defendant, as stated supra in this judgment, has failed to satisfy this court that claimant actually sent DW2 to bank during working hours to lodge the checks of his personal business. Accordingly, I've held that there is no evidence that claimant breaches obligation. Thus, Relief C fails. The defendant counterclaimant read Relief D and E, taken together, sought a declaratory order mandating the claimant to pull down pictures of defendant's LPG tanks from GG and desist from passing off same on GG. Defendant is also seeking for the payment of a sum of 15 million naira as general damages for passing off the defendant's LPG tanks. I've reasoned and held supra in this judgment that the defendant counterclaimant has not been able to prove that claimant allegedly committed this sort of passing off. If it had proved the alleged passing off by claimant defendant to the counterclaim, he will have been entitled to its relief D and general damages. Thus, its claims D and general damages for passing off fail. Now, as regards the allegation of stealing, it is the contention of a defendant counterclaimant that claimant defendant to counterclaim stole items contained in paragraph 40B of the counterclaim, and that a CCTV footage showed how he snuck into the storage unit to steal the tools and equipment. See paragraphs 38 and 40 of the counterclaim. Claimant, in response, read several paragraphs of his reply to statement of defense and defense counterclaim, denied this allegation of stealing. The DVD that was alleged to contain the recording of the CCTV footage, Exhibit E4, has been expunged from the record of this court as reason supra. I'm mindful of the testimony of DW1 and DW2 as contained in paragraphs 40 and 42B of their statements on oath, respectively. The alleged stealing was recorded in Exhibit E4, which has been expunged for reasons earlier given. In the case of Sahara Energy and Oyebola citation captured, the court held that oral evidence of what transpired at the disciplinary proceeding, which was recorded, cannot be given. See section 128, subsection 1 of the Evidence Act. See also the following cases: Gudusu versus Abubakar citation captured, Olawoye and Bello citation provided, in line with plethora of judicial authorities. Since the CCTV footage of the alleged stealing was recorded in a DVD, oral evidence of the content of DVD cannot be given. Thus, the viva voce of DW1 and 2 that claimant stole the alleged items is of no probative value. The defendant read paragraph 17 of the statement of defense, pleaded Exhibit E5, which is a document containing the list of items missing in the storehouse of the defendant. This exhibit is not equally helpful to the case of the defendant counterclaimant, as there is nothing in the said exhibit that says that claimant was responsible for the missing items. Even if Exhibit E8 was not expunged, there is equally nothing in it, which is the application for direct criminal complaint and its accompanying documents that shows that claimant has allegedly stole the items or equipment. Be that as it may, there's even nothing before this court to show that the law enforcement agents have investigated the said allegation and the said investigation indicted claimant. The absence of any credible evidence that claimant actually stole those items or equipment as alleged by the defendant counterclaimant This court finds that the defendant counterclaimant has not successfully proven the allegation of stealing against claimant defendant to counterclaim beyond reasonable doubt. I so hold. It is worthy of note that claimant in his reply to statement of defense and counterclaim, specifically paragraph 55 of the defense to counterclaim, stated that at no time was he issued query or confronted with any allegation as regard any missing item. I must equally state that there is nothing before this court to show that claimant before this case has been confronted with the allegation of stealing. In fact, the evidence before this court seems to show that the allegation of stealing against the claimant is coming up for the first time in the pleadings of the defendant and in Exhibit E8, which was prepared during the pendency of this suit. I say so in view of the fact that the query given to claimant, that is Exhibit H1, did not include the allegation of stealing. In fact, DW1 admitted under cross-examination does, I quote, was there any letter issued against the claimant by the defendant of any theft? Answer, no. DW2 equally, while under cross-examination on the 20th of January 2022, stated that she would not know if the defendant issued any letter to the claimant for stealing. It is thus clear from the above that the allegation of stealing against the claimant is coming up before this court for the first time. It is wrong for the defendant to issue query to the claimant in respect of breach of his obligation for running a private business and then come to court and start raising another allegation which claimant was never confronted with. It is the belief of this court that the said allegation is nothing but an afterthought and a malicious falsehood meant to malign the person of claimant because he came to this court. In view of all stated supra, I find that with F in the counterclaim fails. The defendant counterclaimant in its relief G seeks for cause of action, and by its relief H in the counterclaim is asking for post-judgment interest at the rate of 20% to the entire judgment sum is finally liquidated. There's no doubt that both reliefs G and H are ancillary claims. It is right that where main claims fail, the ancillary cannot be granted. So the cases of Insugbe and Kobe and another citation captured, case of Fafunwa and Bellevue Travels Limited, citation also captured. The main claims in the counterclaim having failed, there's therefore no need to grant the ancillary claims in reliefs G and H. Thus, reliefs G and H fail. For the avoidance of doubt and for the reasons earlier given, I declare an order as follows. 1, the claimant is entitled to be Sorry, Learned Counsel, are you there? My internet went off. So let me quickly conclude. For the avoidance of doubt and for the reasons earlier given, I declare an order as follows. 1, that claimant is entitled to be paid $30,000 as cost of living at the rate of $1,500 per month from January 2020 to August 2021, and same should be paid to him forthwith. 2, the claimant is entitled to his monthly salary of $5,000 for the month of August 2021. The same should be paid to him forthwith. 3, the employment relationship between parties subsisted till today when it was declared to have been constructively terminated by the defendant. 4, the claimant is to be paid the sum of $5,000 and $1,500 respectively per month from the month of September 2021 to the date of this judgment, which is today, the total sum of $65,000. 5, the claimant is entitled to the sum of 100,000 naira as cost of action. 6, the counterclaims fails in its entirety and thus dismissed. The judgment sum is to be paid within 14 days from today, failing which it is to attract 10% interest per annum. Judgment is accordingly entered. The parties are entitled to clean copy of this judgment. You can send someone to pick it up later today or tomorrow. I just observed some typos which will be corrected.
As God pleases. May we speak, my Lord?
Yes.
My Lord, I want to thank you for your erudite judgments. I really appreciate the industry of the fountain of knowledge of my Lord into it, and we really appreciate all efforts. My Lord, we are most grateful.
Very well. Like I said, you're entitled to a copy, which you can pick up at the court. So I will rise.
As God pleases. Can you hear me? Wow.